Good afternoon and welcome to Nuts and Bolts of the Service Contract Act. I know the full name is on there, but we would like to welcome everybody. My name is Nicole Atala. I'm with the law firm of Polero Mazza. We are a business law firm that serves as a strategic partner to government contractors and commercial businesses. We have a lot of different practice groups in addition to labor and employment. We've got a great corporate group, GovCon group, and litigation group as well. Here is my bio. I've been practicing in this area for about 10 years now, particularly with respect to government contractors and prevailing wage laws, and train on this subject matter quite often. So I'm really happy to be here today.
And hi, I'm Mary Holmes with Boost LLC. What we do is we serve GovCons in a lot of different areas in the back office, such as accounting, contracts, recruiting and sourcing, human resources, and strategic pricing. And I am a senior HR specialist with Boost, where I have been working in HR for about 23 years now and have been specializing in SCA for about 12.
All right, so what are we going to talk about? We have a lot of ground to cover today, so I'm going to kind of dive right in. The first, the majority of today is really going to be spent on exactly what we said this was going to be, nuts and bolts. So just the basics, going back to basics for SCA compliance. We are going to cover common challenges in the midst of doing that, and we're also going to cover sick leave. We encourage you all to ask questions. We will try to get to them as they come in as appropriate, but we do want to cover the basic subject matter today. So if we don't get to your questions during the hour together, we'll try to follow up with you. So what is this thing? Many of you hopefully have heard of it, or maybe you're just getting involved in it, or you've worked in this area for years and just need a refresher. But it essentially provides a law that provides that any contract in excess of $2,500 that's performed in the United States and performed for services must have a prevailing wage component to the contract. Again, it's contracts entered into by the federal government and the District of Columbia. So if you have District of Columbia contracts, the SCA clauses are kind of hidden in there, but you want to look for those. It's contracts that are principally for services. That's generally 20% of FTEs or dollar volume on the contract, but generally speaking, the Department of Labor takes a very low bar, and ultimately the Department of Labor is the entity that gets to decide whether the SCA is properly in a contract or not, and they can direct the contracting officer to include these provisions if they believe that it applies. So the threshold is very, very low. It has to be performed in the United States and be performed through the use of those service employees. So we're talking about people that are janitors, secretaries, administrative assistants, you know, any type of gardening, lawn service, some technical type positions. There is an entire book full of these positions, but it essentially is anybody who's working on an hourly basis for services. There are exceptions. For example, there are exceptions for telecommunications. We're talking about general, you know, phone companies, things like that, that are not, you know, typically covered under a typical type government contract. Although some services now on federal government sites are being wrapped into the Service Contract Act and don't fall under the telecommunications exemption. There are exemptions for commercial type services. So I like to think of the example of a McDonald's on a military base. If the McDonald's is in the Pentagon, it's not generally considered commercial and therefore can be covered by the SCA, whereas a McDonald's that might be on a military base where the public can get on is not considered commercial. But things like credit card processing is exempt. For our purposes here today, I wanted you to know that there are some exemptions, but as we'll find out in the next slide, there's some, it's not really up to you to determine those exemptions. You might want to challenge those from time to time, but it's really the contracting officer's determination as to whether an exemption applies or not. So who is a service employee? It's any person that's engaged in the performance of that contract. So if you have we like to think of them as direct bills or people that are working directly in the performance of that statement of work. There is an exception. The biggest exception is employees that qualify as exempt under the Fair Labor Standards Act. And that's that reference in the second bullet to the FLSA, or 29 CFR Part 541. And we could spend probably 2 or 3 hours just talking about the Fair Labor Standards Act and how to determine who's exempt and non-exempt. But for our purposes here today, what's important for you to understand is that in order to determine whether the SCA applies to a particular person working on a contract, the first thing you always have to do is classify somebody as exempt from the Fair Labor Standards Act or non-exempt. Are they a bona fide executive, administrative, or professional employee under the Fair Labor Standards Act? If the answer is yes, that they are exempt, that they are paid on a salary basis, that they meet the qualifications for one of those exemptions, then they are not SCA employees and you do not have to pay them prevailing wage. If the answer is no, that they're non-exempt, then you need to classify them under the Service Contract Act. And Mary and I were just talking before the webinar about whether there are any points in time when somebody that is classified as exempt could possibly be SCA. It would not typically be an SCA rule that govern that. You might have some quirky thing about how you bid a classification under a GSA schedule, or something like that that might govern making somebody who's exempt or otherwise salaried and putting them on this wage scale. But most, 99% of the time, if somebody is exempt, they are not going to fall under the SCA, and there might be some other quirky thing going on there. The contractual relationship does not matter. And what do I mean by that? Independent contractors are still subject to the SCA. So, you can't get around the SCA by hiring an independent contractor. If that independent contractor would otherwise, if they were classified as exempt or non-exempt as an employee, be classified as hourly or non-exempt, then they would fall under the SCA regime and would need to be paid the prevailing rates and fringe benefits that are in your wage determination, which we'll talk about in a few minutes here. A lot of times I get questions like, but Nicole, how do I do that? How do I make sure they're still an independent contractor? And my first piece of advice would be look really closely at whether you can have that person be classified as an independent contractor. Do they meet the test? And if you've been following this area of the law, it's rapidly developing and it's not in favor of classifying people as independent contractors, particularly in states like New Jersey, New York, California. So you need to, in Massachusetts. So you need to be really, really careful. But if you can properly classify somebody as an independent contractor, you can generally cash out any SCA benefit. So we can make that relationship continue to be valid, a valid independent contractor relationship, by carefully managing how we pay and structure those benefits. But you definitely want to take a closer look at that if you have independent contractors. I like to think of the SCA in 2 buckets. What's the agency's responsibility and what's the contractor's responsibility? The agency's responsibility is really first to determine whether the SCA applies. But as I mentioned earlier, the DOL has the final authority over coverage decisions. So what does that mean? When the contracting officer goes out to implement or list a solicitation or put together a solicitation, one of the things they're supposed to do is determine whether prevailing wage law applies. Service Contract Act, Davis-Bacon Act, Walsh-Healy. Once they determine whether it applies and they put it in a contract, if then they make, let's just say they make the wrong decision or it gets challenged either in the solicitation phase or an employee complains about that determination. For example, it's not determined to be SCA, but then an employee complains to the Department of Labor and says, but it should be. The Department of Labor is going to come in, look at that contract, and they can override the contracting officer's decision. This sometimes comes up where a contract used to be SCA, but then the SCA doesn't make it in a solicitation or something like that. But DOL has final authority over coverage decisions. The agency can fight them on it, but ultimately the DOL has that final authority. The contracting officer, in order to incorporate the SCA properly, they have to put FAR 52222-41 in that contract. And typically that's going to come along with, 52222-43, which is a price adjustments clause, but the key is 52222-41, 42, 43. That is really important because the SCA is a creature of contract. If those FAR provisions and the full FAR provisions are not in your contract, the SCA does not apply to your contract. So that's really critical that you understand that that needs to be in there. You also have to have an area-wide wage determination. So in addition to those FAR provisions, the contracting officer needs to add the WD. We call them a WD or an AWD. You see lots of different ways they're referred to. I'll show you a picture of one of those in just a second. But that should go in at the solicitation phase, at each option, extension, substantial change to scope, but no less than every 2 years, if not funded on an annual basis. So if there is a change in your WD from one option to the next, then the new wage determination is supposed to go into your contract and you're supposed to get a price adjustment for that. We generally recommend not getting your own wage determination. There is a place on sam.beta.gov that you can go out and look at wage determinations. If a contracting officer tells you to go out and get your own, or you think that you just should because there's not one attached to your contract, think twice about that, because remember, this is a creature of contract. So at the end of the day, you need that WD incorporated into your contract. You should not be going out to get your own and implementing it unilaterally. If you do that, you could be risking your price adjustment eligibility. You could use the wrong one and then have some liability from the Department of Labor because you went ahead and got your own. So you want to make sure that even if you think you know which one it is, or the CO asks you for it, that you make sure that it gets incorporated into your contract. That's critical. The Christian doctrine is generally not applicable. And for those of you that are familiar with the Christian doctrine, generally that means that some regulations are incorporated into your contract by operation of law. That means you might never ever even see it in the contract itself. That is not the SCA. Again, the SCA is a creature of contract. So it's a contractor's responsibility. First of all, I like to say read very carefully. I know we see solicitations over and over and over again, and they a lot of times look the same clauses seem to be in them, but it's very critical that you understand what is in that contract. You need to pick the correct labor classification from that WD. So you're going to look at that WD, pick the correct labor classification based on the solicitation that you have. So based on the statement of work in that contract, that's how you're going to pick the correct labor classification. Every now and then you will see issues where the workforce was classified in a certain way on the last contract, so you're going to classify them the same on this contract. Be careful about that. It's really important that you classify people the way that you think the work should be performed based on the work that you are bidding. Because the risk is on you. If you classify somebody incorrectly, you're going to bear that liability. The exception to that might be if the contracting officer in the solicitation specifically said which labor classification to use. But be careful about that because the Department of Labor isn't going to care about that. Again, the Department of Labor's position is that it's your job to classify people correctly. And then we can figure out if you have some basis to pass that liability onto the government later, but generally you do not. It's important that you notify employees of their wages and benefits. That means they need to know which WD applies to the contract. They get a copy of that wage determination. They get to know which labor classification that they are classified as. I like to do that in the offer letter and annual updates, but it can be done in a variety of different ways. The important thing is that employees are on notice. If you cannot find a labor classification that fits, you might need to request a conformance or guidance from the Department of Labor. And basically what that is you go to the contracting officer with a form. It's an SF 1444. You say, look, I can't find the correct classification. There is a method to determining what the correct rate would be based on the Directory of Occupations. And there's a conformance guide that kind of goes over this. But if you've never done one before, I would get a little help and read over how to do it. But you essentially fill in the rate that you believe these people should be paid. You have an employee sign off on it and the contracting officer sign off on it, and then submit it to the contracting officer. The contracting officer submits it to the Department of Labor, and you should get a response from the Department of Labor, usually within a couple of weeks, that says, yes, we agree with you, here's your wage determination, or they say, no, there is something we think fits. They generally don't like you to go up, you know, they don't like admin assistant 2 or something like that. You're picking kind of a floor, the highest possible option that fits in the realm of possibility on that, within the WD and the Directory of Occupations. And finally, you have to pay at least the required hourly rate and fringe benefits. You have to maintain a record of all hours worked, and you have to maintain pay records. So that's important. You would, you know, it seems easy, but it's not particularly easy. And we're going to talk a little bit about the quirks here in a second. I know this is hard to see, but if you've never seen a wage determination before, I like to include a picture. You kind of see on the top there, it tells you, on the top left, it'll tell you the wage determination number, which revision number it is, the date of revision. That can be really important to determining whether you have the right WD and whether you need to push back during a solicitation phase as to whether it's correct. I left out all probably the several pages in the middle that go through the different labor classifications, but if you look on the left-hand side, you'll see that each occupation has a number, and that tracks to the Directory of Occupations. The 5th edition is the most recent. You can Google that and pull up the Directory of Occupations. And then if you look towards the end, you will see a couple of different things. You will see the health and welfare, how much you have to pay for health and welfare, vacation, holidays. You will now, this is an older one, but you'll now see a reference to sick leave, which we'll talk about here in a few minutes. It's really important that you go through this and take a look at the WDs closely. Let's talk a little bit more about the types of wage determinations that are out there. So the most common wage determination, the one that I showed you, was a consolidated wage determination. And it has almost 400 occupations grouped by occupational categories. They are based primarily on cross-industry survey data. That data gets old very quickly, so that's why you don't see updates in real time. A lot of people complain that the WDs are outdated, but that's because by the time the survey data comes in, DOL processes the survey data to do updates in the WDs and gets it in there, it's old, right? So we're kind of always working behind the 8 ball. The job descriptions are generally listed in the SCA Directory of Occupations. So they don't capture everything. Sometimes that's why you need a conformance, because it might not be in there. But generally speaking, that's the place you're going to go to figure out how to crosswalk the Directory of Occupations to the WD, to the solicitation. It's really also important that you are looking at what you actually anticipate employees will be doing, not just what the solicitation says. Sometimes the solicitation or the contract doesn't, or the statement of work doesn't have the fullest description of what these folks might be doing. But you as the contractor should have that information. There are different numbers on the WDs. So a couple slides ago, you saw there was a wage determination in the upper right-hand side of the WD. The last 2 digits of that are either odd or even. Most of the time, you are going to see an odd numbered wage determination. Every now and then, you see an even numbered wage determination. And the way that H&W works is different, whether it's odd or it's even. So the most common is odd, as I mentioned. And if you have an odd wage determination, then you are going to pay H&W, or health and welfare, on hours paid each week, up to 40 hours a week. That means you pay it on holidays, sick leave, any hours paid, a vacation a week, up to 40 hours a week. You don't have to pay it on overtime. If you have an even numbered wage determination, you are going to pay it on all hours worked, even overtime, but you don't have to pay it on the paid leave. So you don't have to pay it on holidays, vacation, sick time. Also, if you happen to get an even numbered wage determination, you can average benefits across your entire workforce. So you can, let's just say your H&W rate was $4.52. You can take all the hours worked, all the benefits, do the math, and see what your average H&W rate is. And if your average H&W rate meets that $4.52 an hour, you're fine. You don't get to do that with an odd wage determination, and that's the more common one. Most commonly, you're going to calculate H&W on a per person basis. So did I provide my $4.52, for example, H&W rate per hour paid for that particular individual? It's an individualized determination. Even wage determinations, as I mentioned, are on their way out, but I still see them pop up. I've gotten questions about it this week. So every time you go out to bid on a contract, you should be looking at whether the wage determination is odd or even. There are other types of wage determinations. There are non-standard wage determinations for particular classifications of jobs out there. The Department of Labor might issue a multi-jurisdictional or national wage determination that lists all the localities for one particular job title. And you might see something like that. And if, for example, you have one of those national WDs that lists localities underneath it, and you see that work is going to be performed in San Antonio, but San Antonio is not listed on the WD, you better be saying something about it. And you need to be doing that in the solicitation phase, or as soon as that change occurs, to add that location into your contract. The other type of wage determination is a collective bargaining agreement wage determination, CBA wage determination. And where there's a unionized workforce and you've negotiated a collective bargaining agreement, as long as you turn that CBA into the contracting officer 30 days in advance of the option year, you can get a price adjustment. They'll treat it just like they would any other wage determination. It automatically becomes the wage determination for that contract. So it's really, really critical that if you run into a unionized workforce situation and you are unfamiliar with how to make that CBA your wage determination and how to get price adjustments for those increases, that you talk to somebody who is familiar with it, because there are lots of unique and quirky requirements for timing, what you can get a price adjustment for, what you can't get a price adjustment for. We have, I believe we still have on our website, clairemountain.com, a posted webinar about this, but and how to use CBA wage determinations, but it's they can kind of take on a life of their own. You may need to have multiple wage determinations incorporated into a contract depending on the localities. Are there multiple localities where you're performing work? There may be more than one type of WD that's appropriate. You might have some collective bargaining, you might have a collective bargaining agreement, but the collective bargaining agreement doesn't cover every type of job on that contract because some jobs are not unionized. So you might need a regular WD and a CBA. So it's not uncommon to see multiple types of WDs. You might have a clause called place of performance unknown in your contract. And that means that you, the contractor, get to decide how to perform the work or where to perform the work. Where this is coming up a lot right now is with telework, because so many folks are teleworking right now. And you need to base the wages on where that person is performing work for a substantial period of time. So, it could have been that 3 or 4 months ago, you didn't need a separate wage determination. Now you might be facing a year of work from home if the agency would allow it. And in those cases, you might need another wage determination if you have people working in different localities because they're teleworking. You should also be aware that sometimes the Davis-Bacon Act can apply to a contract at the same time as the Service Contract Act. And if you see both of those wage determinations, it's really important to to address that and figure out whether the nature of work is construction, which is what the Davis-Bacon Act covers, construction, alteration, or repair, or whether it's SCA work. If the Davis-Bacon Act is in there, it's a contract principally for services which has a segregable, like a piece of it that's very clearly construction. It's really important that you understand that SCA requires enforceable wage rates for each classification employed. So, and what do I mean by that? I mean, if you have multiple classifications that one person is working, sometimes you say, oh, maybe they're a general clerk 1 on this day and a general clerk 3 on that day. Those duties have to be clearly segregated. It has to be very clear that on day 1, person worked in this position, and day 2, they worked in position 2, and day 3, they worked in position 3. If they're moving throughout their day and working a little bit of time here and a little bit of time there, you are probably not going to prevail in an argument that they worked part of their time in a lower paid classification. It has to be very clear and segregated. One person can perform multiple jobs, but again, you need to make sure that you're keeping very good records, because the inclination when that person talks to DOL is going to be saying, no, I work all the time in the higher paid position. So it's really important that you keep very good records if you decide to do that. We talked a little bit about conformances earlier, and this is again the process if no wage determination classification fits. Again, there are no intermediate classes allowed. The classification has to bear a reasonable relationship to what's listed on a wage determination, right? So the idea is you have to kind of find what's close, and then we build a rate from there using that SF 1444. All right, let's talk a little bit about wages, and then I'm going to turn it over to Mary to talk a little bit more about fringe benefits. Your wages, you can be paid in a lot of different ways. You can be paid by the hour, piecework, salary, bonuses, any combination of those, right? But at the end of the day, the employer has to maintain records, and the person has to be paid at least the hourly rate that's attributable to the classification on the wage determination. So the most common one I get is about piecework. For example, if you have court reporters, they're often paid by the word when they're typing. And the question I get is, well, it's industry standard to pay by the word, and it will be demotivating if I pay them just an hourly rate. You know, I'm going to experience a loss in production. Well, you can still use the piecework method to allow people to go above or to work harder and get more than that hourly rate. But yes, they're going to have to earn at least the hourly rate that's specified in the wage determination. So keep in mind that the wage determination is a floor, not a ceiling. So you can always pay above it. You have to pay overtime on hours worked over 40. And don't forget that there are minimum wage laws out there that are state-based, and the Federal Executive Order 13658, which establishes minimum wages for government contractors. So if you ever run into a labor classification on a wage determination that pays less than $10.80 an hour for this year, you should think to yourself, wait a second, there's a minimum wage rule for federal government contracts that I need to remember, and I need to make sure I pay first at least the state or county minimum wage. Then I need to make sure that I'm above that federal contractor minimum wage. Usually the SCA is above both of them, but sometimes it isn't. So it's important that you double check all of those things, particularly because states and localities are increasing to $15 an hour right now in a lot of different states. So it's really important that you understand that the higher of any of those wages would apply. I'm going to turn it over to Mary.
So one of the things that's very important with SCA, besides the wages, is health and welfare. So that is paid in addition to the hourly wage that is paid to the employee. Generally, the wage determination will tell you what the rates are. There are generally 2 rates. One is if the sick leave order applies, and the other if it does not. The the health and welfare can be provided by cash or bona fide fringe benefits at the employer's discretion. So what that means is a bona fide fringe benefit that is considered legally enforceable, and it has to be communicated in writing to workers under a defined formula for determining the amount of the contribution. So what that means too is that when you are paying somebody, that information needs to be clearly broken out on their pay records, and it has to define what those bona fide fringe benefits are. Sometimes what I have seen on an operational standpoint is that part-time employees have not gotten the health and welfare when it does apply to them as well. So some of the bona fide fringe benefits are your health insurance, life and disability, dental, vision, can be accidental death, sick leave, anything that's related to a benefit to the employee. One thing to keep in mind is that you can also provide the bona fide benefit as a 401k or pension contributions. However, you have to make sure if you are going to do those 401k pension contributions from the health and welfare that you have that clause or that addendum to your 401k plan. And generally it's called a 401a. Additionally, you can also do additional vacation or holidays. And what that is where you can utilize the health and welfare dollars to buy that additional time. And then the last but not least is cash. A lot of times people or employees have been getting cash, and employers are starting to move away from that and do the benefits and actually put the money into a bona fide fringe benefit. What's important to understand is which one is better over the other. It really depends on what your situation is as an employer. Sometimes cash could be better if you only have a few employees, but if you have more than a few, then providing benefits can be a better route. And reasons for that, it can include not having to pay payroll taxes on those benefits if you're paying them towards a benefit versus cash, as well as you have to take into consideration your workman's comp and any other benefit that is identified as income.
Yeah, and Mary, just to clarify the comment on the 401a, the reason that you might need a 401a is because what a lot of employers like to do is provide a set of benefits or kind of like a la carte benefits. Like, you can take we want you to take our health insurance, but if you have health insurance through a family member, you don't have to take it, you can opt out. Life insurance and disability insurance might be mandatory. Dental, you could opt into. Accidental death maybe is mandatory, maybe you can opt into it. But there's this excess money sometimes that's left over at the end of the day because somebody didn't take health insurance, which tends to be the big ticket benefit, right? That eats up a lot of this money. And so what a 401a allows you to do is essentially dump excess contributions into a 401a. Sometimes they call it a QNEC. Whereas a 401k often requires the matching, and it's not so easy. You often can't just dump whatever's left over into a 401k. There are, parameters around how that would have to work. If you do an employer match, though, you can count that as part of the employer H&W. The other thing to keep in mind, I would just add before we go on to the next slide, is that these are employer-directed benefits. A lot of times employees think that it's their money, and it does go to their benefit, but you as the employer get to choose which benefits they get to take. And so you can decide to Mary's point, you can decide the benefit that works for you. And for some companies, that's cash because of recruiting. You might be going into an area that's really difficult to retain people and they want to retain their cash, and the employees have the bargaining power, right? But it's ultimately up to you to decide.
And then one other thing about the 401k versus the 401a real quick is there are some different parameters around what exemptions you can do. Whereas with a 401k, you can set limitations of how long a person is to be employed or how many hours they have to work, whereas a 401a is the employee is automatically vested at 100%.
Yeah,
So what a bona fide benefit may not be is anything that is inconvenience for the employer. So that is FICA, unemployment, any of the payroll taxes that an employer has to pay on the employer side, any statutory payments, and any of the relocation expenses, travel expenses, social functions, memberships, clubs, those are not considered bona fide fringe benefits. Now, the health and welfare is increased often annually by the DOL. You see this generally come out in the June timeframe, but employees are not entitled to this increase unless you are at a point in your contract where you are being modified or it's a new contract that's issued. Sometimes you can also see them be incorporated in the option year. One of the things that I always think is very important is when that option year comes up, it is always a good idea to go to your contracting officer to make sure that the health and welfare as well as the new wage determination is incorporated into that, so that the contractor can get a price adjustment, especially if there is an increase in health and welfare wage rates. So sick leave is one of the newer requirements under SCA. It is the FAR 52.222-62. It has been incorporated in new solicitations that come on or after January 1st, and it's for covered employees. So what that means is a contract that's covered by the executive order that are governed by SCA, DBA, or FLSA. If it's a CBA, it provides employees less than 7 days of sick leave, and the contractor must provide the covered employees with the difference. There is no sick leave required under SCA DBA.
Yeah, and this one's a tough one because everybody thinks, well, it's SCA sick leave, right? And it's not really. It's an executive order that incorporates it into SCA and DBA contracts. And what's really critical, what I've seen, Mary, is that companies don't understand that this in connection with piece of it, which is it can be somebody working on an SCA contract that's exempt, that's not even subject to the SCA, but they might be exempt salaried. They're also included, as could somebody working in HR, finance, as long as they're working 20% or more of their time on a covered contract. So those folks in the home office that are working 20% or more of their time would also get folded in here.
With sick leave, there's accrual requirements. So it's a little bit different than the vacation benefit, what we'll talk about in a minute. So with accruals, it's 1 hour paid sick leave for every 30 hours worked in connection with a covered contract, in connection with the covered contract. So you have to assume 40 hours are worked in each week in connection with that covered contract in order to be able to really determine how many hours. Now you are not required to keep records of the hours worked, but it's always a good idea to make sure that you have record keeping. You are permitted to provide 7 days of paid sick leave at the beginning of each year versus doing the accrual method. At the end of each pay period, employees are to be notified about the time accrued, so you'll want to have that on their pay stubs. Now, if you rehire somebody within 12 months, you have to reinstate the employee's unused accrued sick leave. And that also, you can also see that at times in some states like California, if somebody leaves the company and you pay out their PTO or vacation time, you'll have to reinstate them with that. So some reasons for sick leave can be a physical or mental illness, injury, or medical condition. If the person is obtaining a diagnosis, getting preventative care for a healthcare provider, is caring for a family member who has conditions, as well as domestic violence, sexual assault, or stalking. These are very important to keep in mind. It's not just about the individual's own personal health. It is also about the family members that they may be taking care of. So what is the documentation? We have to inform employees in writing each pay period of what they're getting for the sick leave. We also have to keep approvals and denials of that sick leave if you are denying that person or if you are allowing them to take the time. Doctor's notes for absences of 3 or more days is important to keep on file as well. And when you're asking questions as it pertains to sick leave, you want to keep those narrow and simply because you don't want to ask something that is covered under HIPAA. And then if there is leave that is foreseeable, you want to ask them to provide that in advance. Sick leave is a carryover, unlike vacation, so you have to allow them to do that for unused, and you can limit that accrual to about seven days.
Sorry, I'm screwing up the slides, guys.
That's okay.
Now,
Now,
I like to think about it as like a bucket, right? So limit your bucket to 56 hours a year, but anything that's in the bucket, you have to carry over.
And it's one of the few benefits you do not have to pay out when a person separates.
Exactly.
Sick leave is one of those items that cannot be counted against H&W benefits, unlike before, especially if this provision applies. You generally want to use your PTO policies and take a look at your SCA rates, because as I mentioned on the wage determination, and as well as Nicole has mentioned, that there could potentially be a determination on the wage determination that identifies if sick leave applies or does not apply based upon when the wage determination is issued. So
yeah,
for no, go ahead,
yeah,
Nicole.
It's funky because you'll still see contracts that don't have sick leave incorporated. So unless that sick leave provision is in the contract, you don't have to pay it. So you have to make some decisions as an organization about how you're going to handle sick leave if you have lots of federal contracts and not all of them have sick leave provisions in it. I have not found a great way to have SCA non-exempt people have a PTO policy because, as Mary will talk about in a second, vacation operates differently than sick leave. So for those people, you really need to think about having sick and vacation policies separately. But for the exempt folks or in connection with folks, you can still use a PTO policy, but it's a good time to take a look and make some organizational decisions about how you want to do that and what rates should properly apply. You don't get to choose. If the sick leave is in your contract, then you have to, you get the 422, but you have to provide sick leave. So you can provide more in an H&W benefit, but you still need to provide sick leave. Sorry, Mary, I interrupted you.
That's perfectly okay. So one of the other things to note in Hawaii is a little bit different. They have a lower sick leave rate because Hawaii requires you to provide their specific health care. With vacation is utilized a little bit differently. What that means is when an individual starts for the first time on a contract, say they're new to the SCA contract, they would not be able to get their vacation until their anniversary date of employment. So if this individual started on 12/1/2019, they would not get vacation until 12/1/2020. So they vest on their anniversary date, and then the amount depends on the years of continuous service. So for example, if say that same individual ended up working until 2025, each year on their anniversary date, they would be allowed to have, would get that bucket. So you get 1 week after a year, 2 weeks after 3 years, 3 weeks after 7 years. With part-time employees, you want to take a look at the number of hours that they worked in the last year, and then you want to do a calculation to come up with a prorated number of hours.
Yeah, and again, you want to look at that WD, and you want to keep in mind that when we say continuous service, it's not just with you as the contractor, it's with any other prior contractor at the same work location for the same or similar contract. So you could have somebody that's worked for prior contractors for 10 years. You start performance on September 1st. Their anniversary date, the first day they worked for the first contractor on that contract they ever worked for, is September 5th, and you could owe them 3 weeks of vacation on 4 days after you start on the contract, which always irritates people. But keep that in mind, that it's really critical that you understand what that anniversary date is, and you may not get that until they start working for you. You're supposed to get them from the contracting officer, but that often doesn't happen.
And something else to kind of add to that as well is sometimes you will find that employers or contractors have not done the vacation correctly. They've done accruals. So that can also play into it where individuals are a little confused, especially if they're on SCA, and you will hear, well, that's the way we always did it. So trying to really put together a vacation policy is important, and being that and getting that communication out. Now, one of the things that can happen is a break in service. That is when somebody is not laid off. It is, say, a contract or you're on an IDIQ task order and the task order ends. Say a new task order doesn't come out for 6 months. You would have to make the determination, is that considered a break in service, or if that is considered a temporary layoff. It's very important to make sure, because you can run afoul of the vacation if you call it a break in service. Break in service also applies to, say, somebody worked for 5 years on the contract and you do apply it as a break in service and they're gone for 6 months and come back, or 7 months and come back, then they would be starting over as a 1 year, starting all over again. When you look at vacation, you would have to pay it out for three different cases. If the employee leaves and terminates, if the contract ends, and on the next anniversary or the next anniversary date. So sometimes and contractors can get that a little bit confused. There are, for holidays, generally there's 10, sometimes 11, and sometimes you can also see where the contract may have like training holidays. Those holidays do not apply. You have to make sure you follow the wage determination and to determine what days are applicable for holidays. Part-time employees is where it gets a little confusing, because you have to look at the hours worked in the week prior to where the holiday falls. From there, you would make a determination of what those number of hours that they would get when you look at those hours. And then you also have to keep in mind if the employee worked during the week of the holiday.
So we'll talk a little bit about subcontracting. Make sure that you're flowing down the SCA provisions and wage determinations to any subcontractors, and any subcontractor, if there's a lower tiered subcontractor, should be flowing that down as well. The prime contractor is ultimately on the hook for any violations by a subcontractor. So I like to see a good subcontract with the flow down provisions in it, the correct indemnification provisions in it, and the right to inspect payroll documentation if needed in order to confirm compliance. Because once that subcontractor is gone, they're gone. The Department of Labor might investigate the subcontractor, but ultimately they come to the prime if the subcontractor doesn't pay, and you would be required to take that up with the subcontractor. I did receive a question about subcontractors marking up for SCA. I think this could be a fact-specific scenario, but generally speaking, if it's a price adjustment issue, they're only going to be subject to the same rules that you would be subject to. They don't get any markup on it. If they're bidding it out of the gate, you can bid it how they need to bid it. But ultimately, they're not going to get anything extra in the price adjustment provision. DOL has sole enforcement authority over the Service Contract Act. What does that mean? It means that an employee can't go out and find a plaintiff's attorney and sue you in state or federal court for violations of the SCA. They have to go to the Department of Labor. The Department of Labor decides whether or not they are going to open an investigation and whether they are going to, find some violation. There is no private right of action. Keep in mind that there's inexperienced contracting personnel. You cannot rely on advice from agency officials as a defense. You can't say, unless the contracting officer puts something in writing and basically incorporates it into the contract, it is not going to be something that you can rely on. So you need to make sure that you understand how to classify people, how to implement correctly, because at the end of the day, regardless of what somebody told you on the ground, if it's not a contract and it's not in writing, it's probably not going to happen. In writing, I mean from the contracting officer. You also can't rely on other government officials. So if you call the Department of Labor helpline and they give you some quirky advice, you know, be wary of that because it doesn't insulate you from liability. The parade of horribles is, practically speaking, you get an investigation, you'll get this document called the WH-56 that says this is what your liability is. You can negotiate with the Department of Labor if you have some basis to negotiate, but if you don't pay, they can withhold funds from your government contract and they can refer you for suspension and debarment. The unique thing about the SCA is that the de facto position is that you are referred for suspension and debarment, unlike the Davis-Bacon Act where somebody has to recommend that. So if you don't settle with the Department of Labor and it goes to a lawsuit at the Department of Labor, the Administrative Review Board, then suspension and debarment is a part of that. So that's their real big stick. The other thing you need to keep in mind is that DOL can enforce this back to the start of the contract. So it's not a 2-year rule. It's like the Fair Labor Standards Act, it is back to the beginning. And so, you know, we see cases with multi-million-dollar liability. You want to make sure, I wanted to talk just very quickly about CBA wage determinations. Again, if they're turned in on time to the contracting officer, they are automatically incorporated as the wage determination. And Section 4C of the Service Contract Act basically protects wages and fringe benefits as being the prevailing wage rates that are applicable to that contract. However, not every expense that might be in that CBA is considered a wage or a fringe benefit. For example, they generally don't pay for overtime premiums, they don't pay for callback pay, things like that. So you need to be very familiar with what is going in that collective bargaining agreement. When you go out, when there's a recompete, the predecessor's contractor is or should be attached to that solicitation, and that becomes the wage determination. You want to make sure, you know, again, I think I included here a list of things that could be or that you should be considering when you're negotiating a CBA and whether or not it can be included in your price adjustment. Things like shift differentials, wages, health and welfare, funeral leave, vacation, holiday, sick. Your CBAs all need to be sick leave compliant at this point in time. It's really important that you get CBAs in a timely manner. It's not effective if a contracting officer receives that CBA or MOU after the award and performance starts on a contract. Generally, the rule of thumb is you want 30 days in advance of that option year. And you need to make sure that you've negotiated arm's length. That means you've negotiated this contract as if you're not going to get a price adjustment. You also need to make sure your rates aren't so high that they are considered a substantial variance in the locality. So when you're negotiating a CBA, my recommendation is negotiate it like you would negotiate it if you had to be on the hook for it, right? And make sure your effective dates, you know, are effective prior to the option year. Again, there are lots of quirky things about incorporating CBAs and negotiating them, and that's really what I want you to take away from today. Price adjustments, there are generally no price adjustments under cost reimbursable subcontracts. Under fixed price contracts, you're going to have that 52222-43 in there. You are only entitled to the difference between the currently hourly pay for employees, not what was in the last WD, but what you currently pay people, and what the new WD says that you owe, and that would apply to wages or that H&W rate. So you get the delta between the two. You do not get G&A, overhead, or profit on that. You just get that delta. And technically, you are not supposed to be escalating your prices either. So if you escalated at the outset in order and captured labor in that escalation, technically you're not entitled to a price adjustment. You don't get both, you get one or the other. So you can escalate your G&A overhead and profit, you can escalate some other things, but you can't escalate the labor if you want to take advantage of the price adjustments clause. Again, you can't get adjustments for, you know, labor costs like tax. You may get things like Social Security, unemployment, workers' compensation. So you can get the taxes and you can get the associated costs for the increase in fringe benefits, vacation, sick days, holidays, to the extent those things increase. But you're not going to get adjustments on your G&A overhead profit, travel expenses, uniform and allowances, things like that. I know we had a number of questions. Mary, can you see? I'm having trouble seeing the questions and pulling down the blocks. Can you see them by chance?
I was trying to open the same thing and could not see them.
So I'm going to try this. So bear with me a second. I have this tiny little box, and I can kind of see it. I think Mary's not a presenter, so that's probably why. Okay, bear with me, guys. I'm going to try to get to one of these questions. The slides will be provided after the webinar. So just keep that in mind. One question we got is, do all non-exempt employees qualify for the H&W stipend? The answer to that is yes, because all non-exempt employees, to the extent they're working on the performance of the contract. So if they are, you know, some people say billable to or directly attributable, doing work in that statement of work, they will get that H&W benefit and stipend, because all non-exempt employees that are working on that contract should be SCA service employees that would be entitled to wages and fringe benefits. Let me see, I've got one more here. Is there any requirement to flow the price adjustments clause down to subcontracts? You should be flowing, that is a mandatory flow down. You should be flowing that down together with your general SCA clauses, because, you know, that one, it's a requirement, but two, that's what they're entitled to and they can float up. Now, you could, I have seen subcontracts where they're flowed down, the price adjustments clause is flowed down, but there's a requirement to escalate in the subcontract documents. And of course, you're not technically entitled to the price adjustments clause if you escalate. So, you know, you might get some questions about that and how you do it, but I would highly recommend that you flow down that particular clause. Got a couple minutes left, so I've got a few more questions. What happens to a WD when an employee on an SCA contract travels out of state to a second home to perform services? Does the law focus on the location of work, or is there a primary residence exception? Mary, I can take this one, but do you have any thoughts on it before I monopolize the questions?
That is a great question, because I've seen that come up. So one of the things you have to keep in mind with a wage determination is it's where the work is performed. So that would be something you would need to take a look into. And generally, what I always like to do is contact my attorney and ask them how it would apply depending upon the number of hours that are worked in the different locations.
Yeah, so, you know, there's no official Department of Labor rule on this, but, you know, way back when Department of Labor kind of said, well, how long are they going to this vacation home? Like, are we talking like they're going for a month or two? You're probably going to be okay to use their primary residence, right? You don't need to switch the WD generally for shorter trips. But if they are going to, like, for example, now there are people that have gone to their vacation homes for the foreseeable future. In those cases, you have kind of a period of time where it might be okay to use the WD you had before, but at a certain point, that then does become their permanent residence, right? So there's no official regulation regarding a primary residence and a non-primary residence, but I would keep tabs on where people are and how long they're there. And after probably about a month, I would be checking in with counsel or somebody else as to how long is this going to last? Are they going to be staying there for the duration? You might need to make some adjustments and ask the CO to incorporate some WDs. You might also want to look at the WD that might apply and see if it's going to increase your cost at all. Who knows? It might decrease your cost. And so that's something to keep in mind as well. All right, we are a minute over, so thank you so much for your patience today. We're so glad you joined us. If I didn't get to one of your questions, either Mary and I will be back in touch, and we hope you have an excellent day.